for bringing this bill. I think you said it best when you said we protect money or money judgments with a higher evidentiary standard currently than we do people's life and liberty. And so it seems to me to be an extremely positive move for the system, and also symbolically a very important step forward to recognize, A, that we've had infirmities in the integrity of our criminal justice system that we need to fix, and secondly, that we've got the will, bipartisan will as a body to do it. And so I'm super excited about this bill, and I just want to thank you for bringing it.
Thank you, Representative McLaurin.
Chairwoman Rich, in the interest of time, and while we're waiting on the sub that you're about to tell us about to come up, if you could just basically tell us what the change in that sub is compared to the version that we have. I think we're operating still off of the old LC number, LC 413138S.
Okay, that is a very easy question. That is a simple change. We simply changed on line 46 the year from the effective date was going to be in 2021, but it is now be 2022.
Which line was that again?
Well, on my LC, it's line 46. It's section 3,
Okay.
the effective date.
And just to remind members of the committee, we're still waiting on the updated LC draft. Coming in right now. Bear with us.
Okay. Thank you. While that's being distributed, I would just like for the committee to know that we have some impressive members of our profession standing ready to answer questions. We have my former evidence professor, Paul Milich, who is now retired, and he was instrumental in the overhaul of our evidence code. We also have some practicing lawyers here, some of whom I actually have litigation with as we speak. John Merchant and Ashley Merchant, who practice in both the criminal and civil courts, who can speak to the different standards. We also have Mark Loudon Brown, who was lead counsel in a bite mark evidence case that was ultimately overturned. And we also have Don Samuel and Amanda Clark Palmer.
All right. Madam Chair, if you want to call one of them to the podium now.
Does the committee have any questions for them, or would you like to hear from them?
I'd like to hear from them.
Why don't we hear from Professor Millich?
Okay.
Oh, and he is via Zoom.
Can you all hear me? Am I being heard?
Yeah.
Yes.
Oh, okay. Thank you very much. And thank you for just a moment of my time to explain how important I think it is that we go ahead and fix something that should have been done when we originally passed the code, but that was such a massive piece of legislation that there were glitches along the way, and this frankly is one of them. And you have an opportunity now to fix something at really no cost, because this is going to be, as some of you know, I teach judges in the state every year, and they complain about, why do we have two different standards for expert testimony? Superior court judges have to apply one standard, which is sort of vague, the old one in criminal cases, and then they've got a very clear standard for civil cases, but they're different. And there should not be guesswork and inconsistency with regard to such a very, very important issue, and that is the reliability of the expert testimony that we present to our juries here in Georgia. So I commend the committee for taking this up, and for Chairman Rich. I think this is overdue, and I'm glad to hear that the stakeholders are all behind this, and that we can make a lasting change to an evidence code. Thank you.
Thank you, Professor. Yeah. Which number are you? Representative Sines.
Thank you, Mr. Chairman. Professor Milich, you taught Chairman Rich in law school. Can you hear me?
Yes, that's right.
Okay.
And
How would you
Andrew,
categorize her as a student?
yeah, she was a very good student, of course. I can't remember what grade she got though.
We're glad to know that the author of the bill has a good understanding of the content because of you. So thank you.
Thank you.
Chairwoman, who else would you like to have speak on this?
If the-
Hold on just a sec. Yes, Mr. Chairman.
I had a substantive question for Professor Milich, please. I just wanted to ask if I'm going to be a party in a civil case, I just wanted to hear the substance. Walk us through the committee. I don't want to be guilty of glazing over the details. This seems like there's fairly broad support to this, but what is the substance of this change? Help us understand that. And if you're a party in a civil case or in a criminal case, what is specifically going to be different as a result of passing this as would be applied today in that same context?
Excellent question. And let's start with civil cases. No change. The same rules that have been applied since 2005 with the Tort Reform Act are still alive and well, and in fact have been unpacked and explained pretty well by our appellate courts. Unfortunately, if you're a Superior Court judge, when you have a criminal case, all that body of knowledge and case law dealing with experts from the civil side is useless. You're going to have to use the old Harper standard, and there's a lot of guesswork involved in that. It hasn't been that well unpacked. So the difference in criminal cases is there's going to be a greater opportunity to scrutinize expert testimony that's offered in those. Now, keep in mind that Daubert has been around for quite a long time now, and courts in Georgia will, in criminal cases, be able to take judicial notice of well-established, reliable forensic science that's used in criminal cases. This is not going to, they don't have to reinvent the wheel. This is primarily going to be used for controversial expert testimony. Let me use an example, a microscopic hair comparison. Georgia basically still allows this under very vague type of standards under Harper. Nationally, the rules with regard to use of that type of evidence are much, much clearer. And so the judges will basically be able to navigate this in criminal cases the same way they've been able to do that in civil cases. Did that answer your question?
Respectfully, no. I just wanted to know specifically: are we raising? Is it harder to get evidence introduced, or harder to get a methodology, i.e., microscopic error? Is it harder to get it introduced as a result of this? It makes you bring a stronger game, as it were, to get something introduced from an evidentiary perspective. Does it make it easier? Just help us understand that. As members of the committee, I mean, our colleagues expect these committee members to understand the substance of this, and I didn't read all those cases you were referring to, so I just want to make sure I'm clear myself. That's all I'm asking for.
Professor, have you unmute yourself in order to respond to the chairman's question there?
What we're going to see, I think, is a closer approximation between how federal courts and other courts, sister states, handle these types of new forensic tools as they come down the pike. And I think that's going to be good for both sides in criminal cases. Both the prosecution and the defense have to deal with the issue of one side or the other bringing up new or controversial expert testimony. And so the whole issue here is how well equipped is that trial judge for navigating that question. And by passing 478, that judge will be able to fall back on the resources that have been developed throughout the country, primarily in the federal courts, in addressing those kinds of issues.
All right. Madam Chair, do you have anyone else you would like to call?
Not unless there are specific questions. I want to point out that this has been the standard in criminal cases in federal courts, including the federal courts that sit here, since 1993. And also, I want to point out that Georgia is by itself. All other 49 states have the same evidentiary standard for expert testimony in their civil and their criminal cases. And with that, I would just ask for the committee's favorable consideration.
Thank you, Madam Chair. Excellent job. I appreciate your attenuation of this huge issue that we have before us today. Is there any discussion from the committee at this time?
Only a motion when
Representative
appropriate.
Sines. Okay, hold that motion for now. Chairman Setzler.
Mr. Chairman, I just want to hear a plain answer about the issue of this. This is probably a great bill. Someone needs to say that it's aligning with federal law. That's all fine. That's great. I'm sure it's a wonderful thing. What is the nature of what this does? Is this an issue? Does it eliminate forms of evidence that have become dubious and can't substantiate themselves in terms of regularity and consistency? Does it create a circumstance where, does it change a standard of proof? I just want to understand exactly what's happening, and saying it's good and it aligns with other, I think the subcommittee needs to hear that taken on in plain terms. That's all I'm asking for.
Madam Chair.
Yes, I'd like to start by saying, asking the question whether it creates a more stringent standard or a higher bar is an oversimplification of the issue. It's fact-based. I believe that a practitioner who practices in both civil and criminal cases and who has had to satisfy the different standards in the different types of cases, maybe John or Ashley Merchant, if they are still available, if they could speak to this specifically. It is just a different standard, and it is a less reliable standard. The standard that we use in civil cases and that federal courts use in civil and criminal cases is the reliability standard that's set forth in the code. And it's just a different standard that is used in the criminal cases in Georgia.
A more reliable standard is an evaluation of it. I just want to hear I'm just asking for the substance.
So the substance can be found in the code section itself. And it is the reliability standard. And again, maybe we can have one of the merchants speak to this.
Yes. Who would you like to call?
John or Ashley Merchant. I believe they practice in both civil and criminal.
John, Ashley, are y'all with us?
I am. Can you hear me?
Yes, we can. Go right ahead.
Hi, how are you? This is Ashley Merchant. Thank you so much for hearing from us. So just to kind of answer your question, the big difference is right now in criminal law, we don't have a reliability standard. We have that in civil. So when we're trying to admit an expert, the judge in a criminal case, they're the gatekeeper and they're trying to decide whether or not to admit this evidence, but there's no reliability standard. All it says is whether or not it's reached a level of scientific stage of verifiable certainty. But the judge does not have to determine that the evidence is reliable and that the scientific method is reliable. That's an important standard. That's an important addition that we have in the civil code. So for civil evidence, it's got to be reliable. So all this is really asking is that in criminal, there's also that reliability standard. It's still going to be up to the judge whether or not the evidence comes in and whether or not the evidence is reliable. It's just adding that language. And so it's giving the criminal code section essentially the same that the civil enjoys, which is a reliability standard.
So I'll ask a question real quick. So what we've seen under the current evidence code is that less reliable, and in some cases totally unreliable methods that are, I guess you could say, submitted as scientific or reliable scientific methods, we have seen those admitted. And this will actually create the correct bar for admitting evidence that has scientific reliability in the field, has been peer reviewed, and is in some legitimate, correct?
Yes, exactly. And it goes for both the defense and the state, because what happens in practice is the state, if they are trying to admit evidence that we would argue was unreliable, then the defense is forced to bring an expert as well to show that it's unreliable. So if this standard is adopted, it would apply to obviously both. And so the defense would actually not be able to bring in evidence that had not reached this level of reliability, that again, the judge gets to decide. So this does not change the judge being the gatekeeper. The judge is the one that's going to be able to decide whether or not the evidence is actually reliable.
Thank you. Chairman Setzler.
Attorney Merchant, appreciate you being with us. How does this affect experts themselves? I understand we're talking about evidence that's maybe physical evidence, but in terms of expert testimony, how is this changing the standard by which an expert witness that was introduced by either side would be evaluated to say this expert witness is deemed unacceptable, they're not truly an expert, versus this one is? How precisely does it change that line? I'm just trying to understand that from a specific expert witness perspective.
Well, it just depends on the expert witness. So it would really change it for scientific type experts. And I know that there's been cases where bite marks, for example. So let's use a bite mark, for example. Is bite mark examination reliable? Are the types of the process that they're using for that, is that reliable? That's the decision that the judge would make. So the judge would have to determine not only if that was something that was evidence that had been scientifically acceptable, but is that evidence actually reliable? And so the judge could actually consider studies on reliability. And so it does raise the bar somewhat, but it only raises it to make it reliable evidence, which is what's important, because we only want things that are reliable to go in front of a jury.
What kind of things under this standard might not be acceptable versus under the old standard? Perhaps it could still come in. How would you draw a specific example of that?
I could give
is polygraph, anything like that? What are some examples?
Well, polygraph is not currently admissible. Another example could be false confession experts. Just for example, it would be very unlikely under this new standard that the defense would be able to bring in false confession experts. I mean, we might be able to at some point, but at this point in time, is that going to meet this new standard? That could be a question of whether or not it would meet this new standard. Sometimes handwriting experts are another example. We've seen issues with blood spatter experts where certain types of blood spatter analysis are reliable and other types are not. The same thing with handwriting experts. Some of those have reached a level of reliability, some have not. So it depends on the type of analysis that expert's doing. But what's important is that it still is going to be the judge's decision. So the judge is still going to be the gatekeeper to determine whether or not it's actually reliable. But there's a lot of evidence and it's evolving. Reliability is evolving. DNA is evolving. Let's look at DNA. Something that was reliable 10 years ago, or was not reliable 10 years ago, may be reliable now because we've had advances in science. So by adding this, we're not saying that there's a whole body of evidence or experts that aren't going to be able to be admitted. It's just that the standard is going to be this reliability standard, and it's of course going to be evolving.
Thank you, Professor. Is there any other questions from the committee for Ms. Ashley? Representative McLaurin.
Thank you, Mr. Chairman. I just wanted to offer to Chairman Setzler, I think the saying goes, wherever two or more are gathered with a lot of questions, there you have a Setzler subcommittee. So I'm happy if you want to get a beer about this and talk reliability, I personally offer that because I think it is a fascinating topic.
Thank you, Representative McLaurin. Are there any more questions for anyone here for more clarification? All right. At this time, I'll entertain any. Thank you, Ms. Ashley. By the way, you've been very helpful. Thank you for your efforts, especially coming as a member myself of the defense bar. This is very appreciated. Thank you.
Thank you so much. I appreciate the opportunity.
Okay, I'll entertain any discussion from the committee. Representative Saines.
The motion do pass.
Okay. Any further discussion from the committee on this? Hearing none. There's a motion, a second. All in favor say aye. All those opposed, no. The ayes have it. It does pass to full Judiciary non-civil committee.
Thank you, members
Madam
of the
Chair.
committee.
Okay, next bill we'll call is SB 226. Senator Anna Vittardi, you with us? Senator Anna Vittardi, welcome.
Mr. Chairman,
Glad to have you with us.
we are very proud to see you ascend into a leadership role, being the senator from Haralson County. So I just want to say thank you
Thank
for
you.
having me today.
Thank you. Go ahead.
Senate Bill 226, I'm working from LC 413138S. This bill came before the committee last year, passed with a friendly substitute. Just kind of hit the highlights. This bill came to me and we began working on this bill in January of 2021 to address obscenity issues with bills and online materials in our school districts across the state of Georgia. The current form of the bill basically creates a complete resolution process for obscene materials that's adopted by local school districts and their boards of education. Once those complaint processes are adopted, basically it's creating an investigation steps for principals and administrators to carry out those steps for the process. The parents are to hear back in terms of what is the resolution of the issue within 30 days. And then the final section basically creates a transparency piece in regards to the materials that would be published for at least 15 days online, so the public can review that as a result of whatever happens with the process. Thank you, Mr. Chairman.
Thank you. Any discussion from the committee? And just for clarification, everybody, and to Senator Anna Vittardi, we had spoke earlier in the day about some date changes. Those have been reflected. We're now operating off of LC 413138S, or excuse me, LC 480511S.
I apologize, Mr. Chairman.
No, that's perfectly fine. Bear with me, y'all.
There should be two copies in the folder. There's the yellow one, but then the white copy is the one that's the current version. 480511S. We have extra copies if for some reason it's not on there. Okay. You pass it on, Rich? The hell?
Just for clarification again, this is LC 480511S. Okay. Chairman Burchett.
Thank you, Mr. Chairman. Senator, thank you again for bringing this legislation. Will you go over the impetus for the legislation, or the purpose or the reason you brought the legislation? I remember that being compelling the last time we talked about this.
Yeah, I think, and I'm speaking as a former school board member for Paulding County before I became elected to this position. Just in the sense of, I think, clarity for parents that may see obscene materials or materials related to books or online materials, to have a way to kind of appeal and have a conversation with the school district related to those materials. I think from my perspective, and I'm only speaking for myself, I think, the policy set up by local school districts sometimes can vary from school district to school district and not be totally transparent and not be totally clear. So I think what we were trying to do is basically create a process that the public would understand in terms of where to go if there was a concern with material, and basically how to go about that process and doing that, so the community would have full understanding of the transparency rules of engagement with the school board.
Very good. Thank you. And as any good piece of legislation that survives the biennium, more eyes get put on it, and there are more.
I've noticed that.
There are more opinions. I wanted to ask you if you would be friendly to an amendment And essentially what this amendment would do would just to add a little more parent input during the process, and particularly if you were looking on lines 48 and 49, let me see of the new LC, make sure that I'm correct. It would actually be under, let's see, education. Inserted after education, a comma, and the words as follow: which shall also include the ability to provide input during the public comment at a regularly scheduled board meeting. And this was brought to further engage the parents during the process, the appeals process, and just wanted to get your thoughts on any type of amendment like that.
No, I'll accept that amendment.
Oh, very good.
Thank you, Mr. Chairman.
Thank you.
Mr. Chairman, do you have any further discussion on this other than what you've already presented?
I don't at this time. No, sir.
Okay. Is there any discussion from members of the committee on the proposed amendment? Who's 25? Josh?
Thanks, Mr. Chairman. And so the chairman's asking for discussion on the amendment. I'm happy to provide it. And I guess maybe I could use that as an opportunity to sort of express a larger concern. I mean, I think one of the things that we should keep in mind when we have this discussion is that this is the Judiciary Non-Civil Committee. This is a committee that is supposed to handle proposed changes to the criminal law. And if you recall, the history of this legislation, this committee, was that originally there was a bill to exempt or remove an exemption for library technicians and teachers from misdemeanor liability, creating misdemeanor liability for teachers if they allowed children to have access to whatever was deemed obscene. So we've come through a process, right? And that process has basically been starting with a piece of legislation and policy that was pretty reactive, and then moving to a place where the legislation appears to be more moderated, more tailored, more administrative, but it doesn't change the fact that we're still in the Judiciary Non-Civil Committee, and that we have not spent the bulk of our time in this chamber focusing on education issues, engaging with teachers, engaging with school boards and professionals who deal with these issues on a regular basis. So one of the concerns that I have, and I think I can tie this, to what the chairman is saying about parent input, is, when you change something, you have to look at the baseline. You have to look at what you're changing from to what you're changing to. And one of the things that I think is absent from this discussion, kind of in the same spirit of Representative Setzler's questions, is, have we done a thorough evaluation of the amount of parent input that currently exists, the amount of administrative regulations that currently exist? I know for a fact that the state board regulations require each school board district to adopt a policy relating to obscenity and harmful materials. And each school board, which you've served on, which you know very well, has discretion to implement such a policy. And then presumably parents have some role in that policy. So I'm not, again, echoing Chairman Setzler, I'm not necessarily saying that I know everything about all those policies, but I know I represent Fulton County and have been and plan to represent Fulton in the future. And their school board is way on top of this, representing tons of students. My concern, and we all are familiar with the news, we're all familiar with the way that people are talking about schools right now. My concern is that we're using phrases like parent input or review, or these like, well, we're just asking questions, or we're just giving parents rights. We're using somewhat neutral or sort of benign sounding phrases to cover up for something a little worse, which is a more reactive, less informed, basically manifested distrust for what our public schools are doing, and creating duplicative, redundant legal mechanisms that provide parents, some parents, not all parents, with an opportunity to use school resources to chill teachers, librarians, media technicians into not providing a full, diverse body of literature and education for public school students. So that is the main policy concern that I have with this legislation and a number of other proposals floating around. If you could address that general topic and the idea of parent input, because I know that you would like to talk about parent input as well, I think this is the discussion and the debate that we need to be having, Senator.
Yeah, I mean, the only comments I'll make, I mean, again, I'm honored to be here in front of a Judiciary Committee. And if I, as a former school board member, the vice chair of Senate Education, can fill the education gap here, I'm more than happy to do that. But I think at the end of the day, we can slice, dice, and, slice up whatever we want to define parent input as, or make that hyperbolic. But at the end of the day, community input, parental input is important. So we can turn that around and twist it. But at the end of the day, it is what it is. And I think why I'm standing here today is to make sure that, we don't have artificial barriers or rules that maybe aren't put in place to allow that transparency. And I think that discussion to happen in local communities across Georgia. And for somebody who, grew up in DeKalb County, and I grew up in an urban environment that was very diverse. I think whether you're in that community or you're in Dallas, Georgia, that I represent today, I think the same conversation goes both ways. So I know we had that discussion when this bill came through the Senate, and it was a bipartisan vote as it came out of the floor of the Senate. And so I don't want to diminish that, parental input at the end of the day is the standard that we should be listening to as it relates to decisions, whether it's textbooks or anything else that goes on in a school building or outside the school building that impacts my kids. Thank you.
Representative Bodie, you number 12. Okay. And just for the chair to clarify real quick, we will not be taking up the proposed amendment by Chairman Burchett and Sub today. Representative Bodie, go ahead.
Yes, can you hear me? Thank you so much, Mr. Chair. Mr. Senator, just like my dear friend and colleague, Representative Josh McClure, I have some serious reservations and concerns. I just want to just take us through a couple of lines, such as line 23 is and when taken as a whole lacking in serious literary, artistic, political, scientific value for minors. And then when I jump down to section 3 and 4 and 5, it seems like to me that the school principal is going to be the only one that's making this determination. And so unlike the current statute where the local board of education is taking these matters in consideration, the local board appoints someone, a media consultant to look at this or specialist, we're going to have a principal who's a non-elected official, basically an employee of the local board of education, to make a determination. What most of elected officials make these determinations, or if this was a civil matter or criminal matter, a judge would make that determination. So that's my first issue. My next issue is, why are we not engaging with the local board of education to make these decisions? Or why are we not engaging with the local school governance board or team assigned to that particular school to take up these complaints? We know that a local school board or a local school governance board or team is made up of community of peers. Most of the time, a local school governance team is made up of the principal, parents, teachers, community stakeholders, and even students. Why would that not be a better determining factor of what's obscene or not? Why are we having a principal to have all of this pressure put on them to make a decision about what should be in bounds as far as student learning and what should be out of bounds?
So I appreciate the question. So the way I read the bill is that the elected officials in each school district, and there's, hundreds of, tens of school districts around the state. And I think it's for each school district, those elected officials who are accountable to the people to set the policy. I think the administrators and principals are carrying it out. And in the bill, it specifically says that the principal or his or her designee. So I think it's giving flexibility to the local school districts to kind of determine what is that process, but also too, for the elected officials who are being held accountable to the people that, one county may deem certain materials obscene versus, another county. So it's keeping that aspect of local control. So I'm not really understanding your question, Representative.
Mr. Chair, if you don't mind, Mr. Chair, indulge me for a moment. If you're saying local control, this is not a local control bill if you want a blanket piece of legislation to control every state or every local school board in the 159 counties. If we're saying local control, let the Board of Education determine how they deal with the books or with the materials in their particular system. We don't need a general bill here at the state capitol to do that. The local boards have been elected to do that, and they should be the ones to do that. Thank you, Mr. Chair.
Chairman Setzler.
Thank you, Mr. Chairman. I would appreciate the author. And I wanted to address the author of the question specifically. Let me take the claim that Whip Bodie raised. Isn't it true that we have a compulsory attendance law in Georgia? Kids have to attend school. Our Constitution, in fact, says kids have a right to a free and adequate education in Georgia, and we've actually, in my time in the General Assembly, have been striving to exceed that, to actually achieve excellence, not just adequacy. But what isn't it true? What this does, this decidedly does not take it out of the hands of locals. This makes the decision the principal, the building leader's decision to take these questions, is it not?
Yeah, and if that principal has a good relationship, is working with district administration, which I think most, if not all of our principals, that's their goal, in running their own buildings, then those discussions are happening within the building and they're happening with leadership. So it's a collaborative discussion.
And with anything, Whip Bodie would say, well, gosh, if the decision is the principal's, shouldn't there be an appeal process? That's exactly what this bill does. This bill sets up a decision at the building level, and the appeal process is managed specifically with who Whip Bodie referred to, the school board. The school board is the appellate authority on this. So in no circumstance under your bill, as it's crafted, would a decision ever get outside of the hands of the school board? Doesn't go to Superior Court, doesn't go to the legislature, doesn't go to the state school board. The appellate authority is set up because there's the decision and there's the appeal within the confines of the school board specifically in every single circumstance, does it not?
That's correct.
So I just appreciate, I would actually agree with Whip Bodie on his underlying point. That's exactly where the decision should be made. And the appellate authority is exactly the school board. More importantly, the first decision is the building leader. Let me ask you this, though, to the author. This idea that it was raised that this is somehow in response to some criminalization of content. My friend Representative McLaurin raised that issue. Isn't it true, though, this bill has a fundamentally different premise? This has nothing to do with this idea of somehow criminalizing that. This recognizes there should be a defined process that every parent should have, and that specifically the only thing that could ever come out of this is that the public have knowledge of the content that's in their schools. I would ask members of this committee, is there any content, and I would ask the author, but I would ask parenthetically to members of this committee, is there any content in any school that school children grades 1 through 12 should be able to see that adult members of the public should not have access to know is being funded by their tax dollars? Do you believe there's any content that 6th graders or 9th graders or 10th graders should be able to see, be sponsored, promoted by the school, that adults should never have access to see? Do you believe there's any such content?
No, I think if at the end of the day, I think sunshine rules apply to every aspect of government. I think sometimes we either ignore, not maybe intentionally, but we don't think about how that applies to the K-12 environment. But at the end of the day, those rules should apply for all aspects of government.
And Mr. Chairman, if I could lastly, I will talk to the author. I've not shown him language. I have spoken to counsel of a prominent school district here about addressing some of the language with respect to the copyright issues in lines 58 through 61. I do think that can be further defined in black letter law. Again, I think that was added by the author, accommodating material licensing agreements, that anything that would be highlighted that's subject to copyright. The author's underlying bill addresses that, but if the council's come to me and ask if in the deliberation, the subcommittee, Mr. Chairman, could provide a little more detail to that and flesh that out in black and white a little bit more. And I would trust the author would be friendly to language that furthers the goal of this and specifies and ties down those copyright requirements.
That's fine. Yes.
Chairman Burchett.
Thank you, Mr. Chairman. We really do have a great process here. We get everybody's intake on a piece of legislation, and we come to a ground that maybe everybody isn't completely satisfied with, but maybe everybody can live with. And I just want to go to a few points that I heard my colleagues say. Representative McLaurin said, well, why is this in Judy non-civil versus being in education? Well, the fact of the matter is this is a legal standard. I believe it's called the Miller standard. That's what is determining what is obscene. And I think that lawyers should put their eyes on that, and legal committees should put their eyes on that to make sure that we get it right. And to tag along on what Chairman Setzler and Representative Bodie said, this bill leaves the determination of what obscenity is to the community. What is obscene in Ware County, Georgia, is going to be different than what is obscene in Fulton County, Georgia. It's left to the locals to determine. What we're doing here is putting an outline in place that says that there will be some due process if a parent decides that, well, this book seems to be a little bit too mature for my third grader. We're putting in a process here that says, well, we have to meet these guidelines and these dates, hard dates to determine whether or not this is obscene. Without that, we've had instances where a parent may come and say, you know, I'm not sure this is adequate or correct for my third grader. And then this, whatever it is, sits on somebody's desk for 6 months or a year and doesn't get handled. So essentially, we're just putting in a set of guidelines so that someone in any community in the state of Georgia will have a determination of when they're going to have their due process to determine if it is correct or right or obscene or not obscene for their child. That's the only couple points I wanted to make, but I also want to thank my colleagues for their input across the board, and I appreciate it. Thank you, Mr. Chairman.
Representative Montan.
Thank you, Mr. Chairman. Senator Anna Tardy, thank you so much for bringing this bill. You're my senator, so I really appreciate you coming.
I feel like in this committee, I'm almost everybody's senator, but
Hey, that's great. I just wanted to kind of talk about a few different things. You know, I heard we have an education gap here on the committee. I just went to Kennesaw State University, in-state school, graduated from Paulding County High School. So I want to try to do the best rendition I can of understanding this. But I think there was a Supreme Court justice that said at some point that when looking at pornography, he knows it when he sees it. And I would have to concur with him. I'm looking at I think it was Representative Karen Mathiak, who's in the back of the benches over there. She had a bill very similar to this bill last year. We covered it. And some of the material that we saw was, you know, I think, and I just want to make sure this is the kind of books we're talking about, because just for the committee's sake to understand, I see one that has a title of Porn Chic, Exploring the Contours of Raunch Eroticism. That is available to children, or Big Box of Secrets, a sexy BBW romance novelette from Steam Books. I'm seeing another one that's called The Secrets of Porn Star Sex, Brilliant Ideas for No Holds Barred Pleasure. And this is available on a service called EBSCO, Galileo, and others. Is that the kind of material that we're talking about?
yes.
Yeah. The reason I ask those, and there's excerpts that are so foul that I can't repeat them in this committee, we're not talking about it let's say a Disney movie who's portraying some innuendo where the parents laugh, but the kids don't get it, right? That's not the case here, correct?
Correct.
This is disgusting, raunchy filth, right?
Correct.
And so I think, with that being said, this is a novel and a fantastic approach. I wanted to clear that up, make sure we're talking about the same kind of material. And since we are, I agree with you, and I fully support that. And great work on the bill. Thank you, Mr. Chairman.
Thank you, Representative.
Representative Byrd.
Thank you, Mr. Chairman. Senator, thank you very much. I'm usually a little bit slow when we're listening to all these things here in Judy non-civil, but does this bill do anything to stop obscenity in the school system? All I'm seeing is that this is to develop a policy to follow for school boards and school board members, that sort of stuff. So my question is this addressing the obscenity that we're talking about, what Representative Montahan just spoke of? I mean, is that going to be addressed?
Yeah, at the end of the day, it does address. I mean, this bill is to empower parents to make parental decisions on what's best for their child. I mean, at the end of the day, parents should have the opportunity to communicate, appeal, discuss, what is the literature, what is the information, what is being communicated within the walls of their school district and outside their school districts that impact communities. And I think this bill furthers that discussion as it relates to obscene materials in the state of Georgia.
May I have a follow-up? So is there anywhere where we have defined obscenity? I mean, I don't know. I mean, what may be obscene for you and me may be different for someone else. So is there going to be some sort of definition or determination for schools?
I think the answer to that question, going back to Representative McLaren's question and others on the committee, is that I think this bill is giving that decision to local school district to decide how they go about that process and defining obscene materials at the end of the day. So again, we're trying to empower parents to make the best decisions for them, for their families and their kids. What you may think is obscene in my household is maybe a little bit different depending on which Disney show you're watching. But I think at the end of the day, our goal is to eliminate things that parents don't want to see.
Chairman Burchett.
Thank you, Mr. Chairman. Representative Byrd, I was going to chime in here. If you look at on lines 16 through 24, that's essentially the Miller test, and that's what we don't want to get into the business of determining what is obscene in the entire state. We want each individual Board of Education to determine what is obscene in their community. That's the whole purpose, and that's what we're our counterparts on the opposite side of are arguing, that we're taking the local control route out of the hands of the locals, but in actuality, we are determining just a process so that they can determine what is obscene. And so that's the test that they will use to determine what is obscene, because like we've said over and over again, that is a moving target depending on where you live.
Let's see, Representative Kendrick.
Thank you, Mr. Chair. So it looks like this bill is a solution looking for a problem. What I'm worried about is, and maybe we can hear from, if the chair allows, from people who are actually on the ground in education around what other policies already exist around this, because I can't imagine that there's not something, either a professional standard or something that already exists for this process. And I know we get very happy down here when somebody brings something to us that we feel like we need to pass a piece of legislation. But if we already have something in place, I would like to know what that piece is and how that differs from that bill. So is there a way to hear from anybody who knows if there is something that is similar or already existing out there, or are you claiming that there is absolutely nothing even remotely similar to a process for this piece of legislation?
Yeah, I can only speak, I'll speak to the school district that I represented or others in my district. I mean, I think the processes that are set up are very informal and not very clear to the public. So what we're presenting today formally, as it is in this bill, does not exist. There may be morphs or, depending on what local school districts are doing, but as it relates to what I've experienced as a school board member, this process does not exist. Thus the need for the bill.
And so you're saying, you're stating in your opinion, you do not believe there's another system set up to address exactly what you're trying to address it?
No, I'm only speaking for the districts that I represent and the school board that I sat on. If there are other school districts and, that feel like they're addressing it, I'm not going to speak for the other school districts. If they're here, I'm sure they would love to weigh in on this issue.
Well, other school districts also, I know that there are different professional standard councils that govern the whole state. So not even other school districts, like, is there a statewide initiative that already can take care of the problem that you're trying to address in that bill? That's what I'm trying to get at. It does something like that already exist? And I don't know if there's somebody here who can definitively answer that, but I don't want to create legislation where something already exists.
Okay, Senator Ambertardy, at this time, we're gonna hear from the audience. We have some people signed up. Chairman Setzler, if you'll hold that, and I'll allow for discussion after we hear from the audience. I believe we have Miss Gretchen Walton from Cobb County Schools with us. Okay. Okay. Okay, thank you. Moving on. Margaret, and I apologize, I'm from Harrison County. I can't pronounce too many names like this, but Miss Margaret Ciccarelli, Chickler. Okay, I was close. If you come over here to the podium or the table.
Mr. Chairman, I'm Margaret Ciccarelli from PAGE, the Professional Association of Georgia Educators, representing about 93,000 educators statewide, everybody from classroom teachers, superintendents, school bus drivers, et cetera. Regardless of how this bill wound up in this committee, we are very appreciative of the changes that it has undergone throughout the process. I was going to waive, but since I'm up here anyway, I just wanted to say we do have a small concern about copyright issues. Georgia public educators are pro parental transparency and want the public, particularly parents, to be knowledgeable about what their kids are learning. And I say that as a public education parent myself. So if we can address that copyright issue through the lens of not getting schools in legal trouble, but making sure that parents have access to view the material, that would be the ideal way to thread the needle on this legislation. And we look forward to continuing to work with the author and this committee as we have worked on it as it has undergone the legal process thus far.
Okay, thank you.
Thank you.
I believe we also have Brother Mike Griffin from Georgia Baptist Association here that wanted to speak about the bill.
Thank you, Mr. Chairman. I am Mike Griffin. I am the Public Affairs Representative of the Georgia Baptist Mission Board. And we represent approximately 1.3 million Georgians and up to 3,600 Georgia Baptist churches. And this last year at the Georgia Baptist Convention, we passed a resolution dealing with our concerns generally regarding the library exemption regarding obscenity in our schools. So we're very concerned about this, but we do believe that this is a very important piece of legislation because it makes a step in the right direction that I think that everybody should be able to agree with. And it's basically being a Baptist preacher. So let me give you 3 words to go with this in an outline. Okay. Number one, it's about transparency. And again, if nobody has anything to hide and if there's nothing obscene, then shining the light on it is absolutely no problem whatsoever. Matter of fact, it will reveal that there is nothing wrong. But if there is something that should be dealt with, it brings me to the second word, and that is the word protection. We do have a responsibility to protect our children, the most vulnerable that we have out there. Georgia Baptists were the only denomination that supported both hidden predator acts, those pieces of legislation to deal with predators. And we're now concerned with holding entities accountable. And one of the main things in dealing with sexual predators and sex trafficking is the grooming process. And we're concerned that the over sexualization of our children is contributing to the problems that we're trying to stop. And so an ounce of prevention is worth a pound of cure. So the transparency, the protection, and then thirdly, accountability. Accountability is a good thing because, again, people that are doing the right thing want you to know that they're doing the right thing. And there's no doubt about this, that it does put that authority in the right places with the right people, with the parents, school board, local folks, and to be able to display that out there so that the community can see it and they can, affirm the direction the school's going or say, hey, that's something that we don't like. So that holds them accountable. I think it's a good thing. And I appreciate Senator Avatarte for what he's been doing and his hard work on this. Thank you, Mr. Chairman.
Thank you. We also have Terrence Wilson signed up to speak.
Good afternoon, Mr. Chair and members of the committee. My name is Terrence Wilson. I'm the Regional Policy and Community Engagement Director for the Intercultural Development Research Association. We're an independent, nonpartisan education nonprofit committed to achieving equal educational opportunity for every child through strong public schools that prepare students for access to succeed in college. We are opposed to this bill because of the threat that it poses to the access and use of curricula that affirms the identities of all students, particularly students that identify as part of the LGBTQ community. While the bill drafter's goal of protecting students is laudable, the provisions contained within this bill may in actuality do the opposite. In fact, in operation, this bill threatens students' access to materials that may eventually be covered and protected by the First Amendment of the U.S. Constitution. While the bill's language appears to incorporate the Miller Standard, as the chairman mentioned before, this is a high bar, and we feel that placing the responsibility for interpretation of this high bar, not with judges or other trained legal professionals, but rather with local school principals or designees that aren't specifically trained to make these determinations, is a problematic approach to these bills. As the chairman mentioned, it takes an opportunity for lawyers and other folks to be able to set the standards listed here. We think that it's foreseeable based on this process that a lot of the information that would be prohibited might actually be information that is going to be allowable under First Amendment protections. We ask that the committee remember the words of the Supreme Court written in Aronofsky versus Jacksonville back in 1975, which says that, quote, minors are entitled to a significant measure of First Amendment protection, and only in a relatively narrow and well-defined circumstance may government bar public dissemination of protected materials to them. The court went on to state that speech that is neither obscene as to use nor subject to some other legitimate prescription cannot be suppressed. Solely protect the young folks from ideas or images that a legislative body thinks is unsuitable for them. Thus, we think that you all should consider rethinking the wisdom of creating this system that will likely lead to protected content being restricted. Furthermore, beyond legal considerations, we believe that this bill is likely redundant based on the current provisions outlined in the Georgia rules and regulations that are available for you all to review. As Representative Kendrick asked for, there are several rules that govern these kinds of issues, specifically Georgia Rule 160-4-4.01, which governs instructional media resources, Georgia Rule 160-4-4.2, which governs instructional materials advisory committees to be set up that include parents and other local folks in the community, and instructional material selection and recommendations found in Georgia Rule 160-4-4.10. These provisions value local control and include parents as an important part of the process. Likewise, the current provisions value the expertise of our educators and our media specialists and our librarians who are trained to choose appropriate materials for young people to access. Finally, we are concerned that under the current processes proposed in this bill, materials that cover topics from minority perspectives and that explain and address themes including racial and ethnic minorities, LGBTQ+ individuals, and religious minorities may be removed or censored. We've seen this happen in other places that have enacted similar provisions to the ones in this bill. For the aforementioned reasons, we ask that this bill be withdrawn and instead legislators enact measures to bolster community-based approaches to ensuring that curricula and instructional materials affirm all students' identities. Thank you.
I believe next we have Noel. Oh, pardon me, Mr. Wilson, if you come back real quick. Chairman Setzler.
Mr. Wilson, thanks for being with us today.
Yes, sir.
Wanted to ask you, I'm fond of quoting President Obama, who said an appeal to first principles is useful. It really gets right down to the heart of issues, and I appreciate his perspective on that. I would echo that. Let me get right to the heart of the issue. We talk about some folks have some details to work out on in the language, and it's very important we get the details right. But in principle, do you believe that members of the public, taxpayers, adults, should be able to have access to see all content that minors in our public schools have access to?
In principle, I believe that parents should be a huge part of the process, and I believe that our current regime that we have in our rules and regulations cover that involvement and that ability to see those materials.
So I'm going to ask you an uncomfortable question because I want to go right to the point. And you partially answered my question, but you did answer it.
Okay.
Be very specific. Do you believe parents ought to have access to every single piece of content that's made available to their minor school kids?
Yeah, I believe that parents should absolutely be able to understand what students are learning in their schools.
Broadly learning, but specific on a content by content basis.
Right.
Every single image, every single word of text. Should parents, if they ask and go through the process, should they be able to see every single thing that students have access to in the schools?
Yeah, it is my belief that parents currently have the ability to be a part of not only what their students experience, their own individual students, but also a part of the process where we determine what students can learn. So I believe that they already have that ability.
Part of the process, but so you believe today, well, it's debatable whether they have it today, but it's a first principle question. Do you believe that every parent ought to have access to see any piece of content that's available to kids, even if they may not appreciate the content, or even if they're not the ultimate deciders on whether it should be there? Should any parent be able to see everything that their kids can see?
Yes, I believe that's already the case.
So you believe it should be, you believe that parents should be able to then?
Yes, and I believe that they have the ability to do that under the current rules. The problem that I have with the bill is not in parents having the ability to see what their children are learning. It's actually the part in the bill that would prohibit and censor what students can learn based on these rules that are hard to interpret and that don't have the same processes where lots of different perspectives are included. So if me as a parent, I wouldn't want what I determine to take away an opportunity for another child in the school. So that's why we have a collaborative process as it stands.
Okay. I'm not sure we're reading the same bill. I'm reading LC 413138S, and in 413138S, in nowhere are parents taking away content. Only educators, principals, and then people ultimately under the school board, the school board itself, the district level, are making those determinations under the bill we're debating. So there's no issue about suppressing that. This is simply an issue, if you're reading this version of the bill, is that anything that kids can see, parents and the public have access to see themselves. There's nothing that can be said. That can be, hey, kids can see this, but mom and dad can't really know that it's being seen.
That is one part of the bill. There is another part of the bill, right, that would allow a principal, as you mentioned, or a designee to say that this bill is harmful to minors and for that content to be suppressed or to be censored. So that is a part of the bill that concerns me.
Well, if you're a principal though, and I were a parent, for example, and I came to you and said, hey, there's this content here that I think is objectionable. You looked at it and you thought, And I wouldn't hold you accountable as a principal that every single book on the shelf of your school, you've read every word of. So I would expect, hey, Mr. Wilson, I've got this, take a look at this. And you looked at it, and he's like, oh my gosh, this is not consistent with the values of the DeKalb County schools or Cobb County schools. Thank you, Mr. Setzler. We think this is, good catch. This is not appropriate. Maybe it was appropriate sometime in the distant past, but it ain't appropriate today. So it's gone. Wouldn't you thank me for that?
Yeah, I would like for it to be a systematic process. Even if I were a parent, I would want every other parent that's like me to be able to have that same right. And so I think that we don't want it to be a case by case basis in terms of having different standards for different materials. I think that what we want to have is a comprehensive, systematic approach, which is what is reflected in the current regulations.
Yes, systematic, and that every parent have that same right. And that's exactly what this bill does, that every parent in Georgia has that same right. Some districts might accommodate this today quite well, but every district does not. We know that. And we believe, as you said, every parent should have the same right to a systematic approach. And we talked about 180 different school districts. And it's Representative, one of my colleagues said before, it's different every place. Why do we need a common process? Well, this isn't being decided. I know you referred earlier, the legislative body believes it's obscene. We're not making those decisions. What we're doing is, to your words, setting up a systematic process that every parent has a right to follow to make this happen.
And then to ban the materials is the part.
No, but the school leaders are making those decisions, not the parents, but the school leaders. The school leaders make the decision in every single circumstance. And to the point you agreed that every parent, adults should have access to what the kids can see. That's exactly what this bill does, Mr. Chairman.
I think we may have a different understanding of what exactly the bill does, but thank you, Mr. Chairman, for your questions.
Go ahead. We've got another question over here. From Representative Bodie.
Yeah. First of all, thank you so much for being here. And we appreciate you presenting to this body. Now, you said something that caught my ear earlier about principles. And will you not agree that right now, even some of our Metro County boards of education have had hyper political meetings where it has been disruption? Now, with this legislation, that political pressure would now be on one person. Is that not true? The principal.
That is correct.
And then the principal will have to deal with the fallout, not at a school board meeting, public school board meeting, but within their office and at their school themselves.
That is correct.
Thank you so much, sir.
Any further questions?
Chairman Burchett.
Thank you so much, Mr. Chairman.
Chairman Burchett does have a question, Mr. Wilson. Mr. Wilson.
Yes, sir.
Thank you very much for your testimony. Just tagging along what Representative Bodie and Chairman Setzler said, you pointed out the current statutes 160-4-4. And if I could read from an excerpt from there, what it allows is development of procedures for the school system and for selecting material locally, handling requests for reconsideration of material. Would you agree that this is the same thing that we're doing here? Handling requests for reconsideration of material, but we're putting deadlines on those requests?
It is my assertion, yes, that we are trying to do the same things that already exist in the regulations. Yes, sir.
Thank you, sir. And at this point, the way the statutes stand right now, though there is no provision within law that takes away that decision from, we don't know who makes the decision now, do we?
And which decision? Can you be a little bit more
decision
specific?
For what is obscene and what requests are, what materials are requested to reconsider?
I believe that in that regulation, there's a list of folks that are mentioned that should be included, I believe.
So what I'm seeing here is that they are to develop procedures and school systems. So what we're doing here is essentially in line exactly what you referred to. We're just outlining deadlines for this thing to be, for these materials to be seen about, whether they're obscene or not. We're not changing anything substantively of who's making this decision. We're saying that the Board of Education locally must make that determination in a reasonable amount of time versus just, letting it sit on someone's desk.
No, I understand. And I think that, the opportunity may be there to work within the regulation, but it is our contention that this bill is not necessary and may be redundant for, as you mentioned, because some of the rules are already there. So if the committee has a desire to protect students, which I think is laudable and we want to applaud you all for, maybe it's an opportunity to go into that legislation, work with folks, as we mentioned, from the Department of Education, other community groups to do this instead of doing it here at the legislature.
Well, very good. I appreciate you again for coming out here and
Yes, sir.
giving testimony. Thank you.
Thank you. Any other questions?
We do have one Representative
popular debate.
Montahan.
Thank you, Ms. Wilson, for coming in and giving your testimony. I do have a
Yes,
couple
sir.
of questions. You had spoke about the narrow kind of lens that we're looking through for the First Amendment rights of the children. You know, and I'm trying to find out where that's going to fit. And so you as a professional, what kind of books do you think should be censored?
I think honestly, it's going to be a case by case basis. It's going to be based on what the student's level of development is. I think the problem that I would have is here, from my perspective here, trying to predict what kinds of materials are going to be considered obscene under this rule.
Further question then, let's say in your profession, I know you had a pretty good statement on this. So let's say for an 8th grader, what would you say you shouldn't expose an 8th grader to?
I'm an attorney. I don't feel comfortable speaking on what 8th graders should and should not learn. I think that we can have a process that's informed by child development, educators, you know, all the different folks that are listed. So I unfortunately cannot speak to what's appropriate for an 8th grader.
Well, I am not an attorney, so I understand. What would you tell somebody who says that maybe the procedure isn't working? You talked about many procedures that are currently in code. You said, you know, these procedures are working. But I'm looking at, you know, again, this is accessible to an 8th grader. It says torture porn in the wake of 9/11, horror, exploitation, and cinema of sensation, or secrets of porn star sex, brilliant ideas for no holds barred pleasure. And again, even the chapter titles, I'm just trying to understand if, as a professional, you believe that fits within the narrow lens that should be censored.
I think that we should leave those determinations to the folks who are closest to school children. I think if I had an 8th grader, I think having things in EBSCO hosts might be a different determination as to what's actually being utilized in the school. That would be a question for your librarians and for your educators. I think also we just have to be aware of the fact that our students have access to all kinds of things via their cell phones. And so being able to determine what they should and shouldn't see, I think that it would be hard for me to sit here and say what an 8th grader should or shouldn't have access to. But those would be my considerations. I would leave that determination into the hands of the folks who are closest to education that can make those decisions. Our educators, our librarians, our library media specialists, folks who could work together to do that.
I mean, just one more, Mr. Chairman, if you will. I just want to kind of back up lens. Again, I'm not a lawyer. I'm from Kansas State University. I know you know, some places folks went to some bigger schools and some more knowledgeable places. From what I understand, I thought it was a pretty good school. But just from an outside
Agreed.
lens, I mean, right off the rip, just off the cuff, I'm just looking at this issue from maybe a 30,000 foot view. We probably shouldn't have, you know, an 8th grader looking at torture porn. Just throwing that out there. So I guess my question is right off the rip, that is, you would say, hey, look, we really need to dive deep into this issue and find out if an 8th grader needs to look at torture porn. I'm just asking the question.
I don't know if, you know, what the students should be learning. It depends on what their educators feel is, you know, they're responsible and their maturity level. I would say that I think that the problem comes in subjectivity, right? So you may have a closer, like we may agree on something like torture porn, for example. We may or may not agree, but they're in practicality, but I think there are things that will be in the middle. And for us to have a process that we can work together to understand what some of those community standards would be, because subjectively leaving it up to the principal, I think is problematic because they may have a different view than I may have as a parent, and it can go both ways, you know? So I think that's the problem that we should really be considering, is who we can be bringing into this process, right? To be involved with these decisions on the front end. So I'm sorry I couldn't answer your question directly, but that's kind of how I believe.
No further questions, Mr. Chairman.
All right, committee, knowing we have some language we're going to work on with
Thank you.
Senator Anafarty. And thank you, Mr. Wilson. Knowing we have some language we need to work on, we will continue to work on this and we'll get us another subcommittee hearing scheduled so we can get this rolling along. And at this time, I'm going to call HB 566, and this will be a hearing only on 566. And just to clarify, if you were here on 226 and you weren't heard today, I will let you speak when we schedule the next committee hearing. Thank you. Okay, Chairman Burchett, I believe we're working off of LC number 480510S, correct?
Which one did you say, Mr. Chairman?
LC 480510S.
Yes, sir.
Okay.
Thank you, Mr. Chairman. Thank you, committee members. I know that sometimes we get very deep into the weeds on these bills, but I think that's necessary in subcommittee, and we parse out this language best so we can turn out a product that's perfect for the state, or best for the state, excuse me. House Bill 566. I'm going to give you an overall, and this legislation is a piece of legislation that we're going to continue to work on, but I want to present it again to the committee. Like I said earlier, we dropped this bill last session, had a hearing on it. And as it sat, there's been many different opinions as to how to best handle the issue that we're concerned with. And as with anything else, when you get multiple attorneys involved and you have many differences of opinion, and that's where we are now with House Bill 66. We've went through many iterations, but here's the example, and then I'm going to let the gentleman from my district that initiated this legislation come up and give his testimony, and then we'll continue on working on this piece of legislation. Well, here's the issue. In the event that there is a car accident and there's severe bodily injury, perhaps even a death, the instance that we had in my district was there was a car accident and there was a fatality. And during the accident or sometime thereafter, the victim that perished during the accident, the BAC was taken on that victim or party, excuse me, not victim, my apologies. And then the other driver's BAC was not taken. And so through litigation, they were able to find that and get that admitted, the BAC from the hospital, and found that the driver was under the influence. So the problem here, it comes down to search and seizure laws, and we can't put a bright line test into statute that allows for just the determination of probable cause. That's what continually comes up, and there's many Supreme Court precedent out there that deal with this issue. And we thought we had it with the language that we've got in this substitute. Well, as soon as we got over that, what we perceived a barrier, a very intelligent attorney brought up another issue that we have to get by, and that's the Georgia Supreme Court, where we have what is considered testimony evidence. And so this is where we are now. We've crafted a bill that essentially says that when you have a severe, when you have a few instances in play, then there is presumed to be the probable cause. And that is that if you have exigent circumstances, there's an emergency. If the officer presumes or smells alcohol and there is an accident, then probable cause would be there to go ahead and get the BAC and not have to go after go get a warrant for that. That's what we were after. And I think that we threaded the needle, fairly well here. But then just this morning, and I think, is Jill Travis still here? She's going to come up and speak. Will you come up and speak to the portion that you found out this morning? Jill brought up to me a few minutes before this committee hearing another issue that we have to overcome. And so essentially what I'm trying to do is smoke out any other issues we will have with this issue so that I can get this legislation crafted and get to the issue that I'm trying to get to. And that's just that if we have severe bodily harm and there's an accident and you're driving on our roads, that we can get a BAC of the parties involved so that we don't have the instance that we had occur in my district for anybody else. With that, I'm going to open it up to questions or turn it over to the folks from back home.
Thank you, Mr. Chair. Any questions from the committee at this point? They see none. I believe Ms. Jill's here to speak. Well, sir, if you could just tell us who you are and where you're from.
Okay. Thank you, sir. I'm Johnny Lamb. I'm the widow of the late Sheila Lamb. I'm from Lanier County, Georgia. My wife and I, we were married for 27 years, and we were high school sweethearts. Had 3 lovely girls, Courtney, Candace, and Cameron. My wife was killed by a habitual drunk driver, and there was no BAC taken on August 25th, 2011. Also, I'm a staunch advocate of Georgia Mothers Against Drunk Drivers, and also I'm an honorary member of the Sheriff's Association and a constituent of the Honorable Mr. Chairman, Honorable Bichette. And I thank you for putting this bill forward and all the co-sponsors. Why am I here? Today I'm here because I would like for this subcommittee to hear me and hear all the individuals out there in Georgia where there have been incidents where a fatality occurred. In my case, I'll tell you my story briefly in a moment, if I may, Mr. Chairman. My wife was killed on impact, and she was given a BAC at the mortuary by the Georgia State Patrol officers that collected the blood sample. To me, it tells me, yes, that is being objective. But however, the offender that killed my wife, he did not receive a blood test by law enforcement. He received the blood test by the hospital, which according to the district attorney's office is quote unquote unreliable for state prosecution, which that's here and there. My take is, according to the existing Georgia laws, we have the official code of Georgia 40.5.55 that says if someone's involved in an accident and there is a fatality or someone has serious bodily injury, there can be a BAC taken. So the law is there, but however, the enforcement is very subjective with the current articles, Article 3, Chapter 5, Title 40 of the Official Code of Georgia. That needs to be tightened up, where if there is a fatality or serious injury, the law enforcement officer that responds to that incident should must provide a reason if there is or is not a blood sample taken. To say, quote, excuse me, I don't think blood alcohol is a factor in this crash. That is very subjective. And therefore, the law enforcement, I know they have a tough job, but however, they're making decisions for the district attorney and for the judges on the side of the road. Here, if I may also give you just another scenario, a murder and a victim that is killed in a DUI, there's no different. They're deceased. The murder victim, the law enforcement officer, he comes up and he or she he would collect the evidence. He would get the smoking gun, the weapon, the bullet for ballistics. In a DUI, if the officer arrives, he should get physical evidence. Where's there cans of beer or whatever land in the crash scene? However, there's invisible evidence. If he or she does not get the blood alcohol content within X amount of hours, you can never get that back. And I've been in that situation for the past 10 years and 6 months. To this day, I don't know why the Georgia State Patrol did not get a blood sample from the individual that killed my spouse. So if I may, I apologize. I'm a disabled veteran as well. I was a Lehigh County Commissioner for one term, 2009, 2012. So this is very emotional for me, and it's very, very important, this subject, not only for myself, but all Georgians, because no one should have to go through the legal battles, court delays, financial burdens that I had to go through to get to the point of where the individual pled guilty. 2 years and 11 months that it took me to get to that point. That was a lot of frustration. Excuse me. So I would like for this subcommittee to really review and consider this legislation and approve it. So therefore, law enforcement have a better mandate to take blood alcohol contents when there is a fatality or serious injury at a vehicle crash. Also, I've shared with the Honorable Bichette, due to my late wife's tragedy, she was headed to work at 6:15 and 6:20 a.m. to Moody Air Force Base. She was a youth center advisor. She was 1 mile from the gate, and she was head on. She loved taking care of children. She was there for myself and the military families to help the Air Force mission readiness for Moody Air Force Base. So she played a big part into the kids' lives at Moody Air Force Base. But my point is, once this legislation is approved, I would hope and I would seek that the legislation would be entitled Sheila's Law for her sacrifice and dedication to the military community. I'm sorry. Next, if I may, just 1 second, just throw out some data for you. This is verified data that I provided to the chairman in his folder, which I provided previously. The National Highway Transportation Safety Administration data in 2018, from 2009 to 2018, reflects 78% of Georgia's vehicle operators astoundingly received no blood alcohol tests in crashes resulting in fatalities. Survivors do not get blood tested. The deceased get blood tested. Why? Why not? In House Bill 566, it emphasized law enforcement needs, if they believe or they have a reason to believe there is no alcohol as a factor, they need to put that in that report. And if I may, I'd like to show you this. This is a 266-page Georgia State Patrol Special Collision Report. I've read it many times. There's no word in here why and why not. There was not a BAC ticket. So basically, it is subjective. Enough is enough. We need legislation to make sure justice is done for all of our public individuals on the road and increase our public safety with the House Bill 566. And the reason why I said it increased safety is because right now, habitual DUI offenders is a vicious cycle. The system is broke. Case in point, I'm aware of Mr. Chad Mickler. He was working on I-285. He was 21 years old and he was killed by a DUI individual. And that individual that killed him got off on probation. So therefore, that person would be out on probation and then the cycle starts again. So we need to fix this so habitual offenders are held accountable. Law enforcement have the mandate. They need to make sure that BSEs are taken And if they're not taken, why not in that legislation? I'm closing. I just one last thing, if I may. I thank you for your time as well to speak to the committee. Last thing I'd like to say is Sheila can't speak now, of course, but House Bill 566 is desperately needed to be approved out of the committee for a final vote, because driving in Georgia is not a right, it's a privilege. Also, if I may, to the board members and for the chairman, one last thing, if I may, if it's okay, sir, if I may have a display, I'd like to show, and this will, a picture's worth a million words, if I may. You have this in your folders as well. It says House Bill 566, Sheila's Law. My wife's first name is Sheila. This photo here is my late wife's car that was hit head on. So any reasonable person would assume there's something wrong with this crash scene. There's something wrong. This is the offender's truck that ran into my wife head on. Every day I relive these images, because this is me right here in this vehicle as I came to the crash scene to verify that my wife was deceased. And then once I saw the crash scene, in my mind, as a law-abiding citizen and a military person, I assume all thorough investigations would be done for this crash. But however, it was not. There was no BAC. So if you would just take a look at it, and like I say, it's in your folder. And this it's horrible to have to live through that and not know for myself why there was not a BAC taken. With that said, I thank you again for your time. And one last thing I would like to pass on to the chairman, if I may. I have not rested on seeking better laws for Georgia for DUIs. And if I may, I'd like to submit this to the chairman, because I have written to our former governor, Governor Deal, in 2017. I have a reply here, which I'll provide to the chairman. Also, I sent a letter requesting why there was no BAC taken. I sent letters and requests to the previous Colonel Mark McDonald, the Public Safety Commissioner. To this day, no reason, no answers why there was no BAC taken and why it was not in the Georgia State Patrol skirt report. For that, I pass this over, and I thank you again, and thank you for your time and consideration.
Thank you.
Mr. Chairman, we're a state of laws, and the fine troopers and public law enforcement, they're bound by those laws. So we understand that the law is what it is, and they can only do what they could do at the time. So what we're merely looking to do here is try and draft a piece of legislation that, one, adheres to the jurisprudence at the national level, Supreme Court, and at the state level, and also would, in a scenario like this, bring about justice. That's what we're after. And I appreciate the committee indulging us. And Mr. Lamb, thank you for coming up. I do want to hear from the opponents of the bill, because we want to make sure that the legislation that we can drop is a piece of legislation that will be upheld. We don't want it going across the street and getting struck down. That's that would be a failure, in my opinion. So I want to make sure we're doing it right. And in the event that we can get something structured, I'd like to hear it again if we could. I'm gonna leave it at that, Mr. Chairman.
Okay. At this point, is there anybody that wants to speak against the bill, or in favor, or somewhere in between? Miss Jill Travis, Gackel, welcome.
Welcome. Happy New Year, everybody. This is my first day down for the legislative session, so it's nice to see you all again. My condolences, my sincere condolences. And I don't want my commentary to be seen by Mr. Lamb as any kind of edict against the right thing to happen. In my mind, the right thing that should have happened is that police officer should have gotten a search warrant and we wouldn't be here today. And that could happen. That could have happened. The police officer that was investigating that accident could have gotten a search warrant. And that's how we get evidence against somebody. There is, of course, the Fourth Amendment that protects us from search and seizure. And then we go to a judicial body and obtain a search warrant if there's enough probable cause for it. And then there's a case or there's not a case, depending on what the circumstances show. I have to tell you that the only bill that I've seen is and reviewed thoroughly, or not actually so thoroughly as I could wish, is the bill that was filed, LC 412812. I did hear the chairman mention that there was a substitute today. I'm on favorable terms with the prosecuting attorneys, and they were nice enough to share that with me, but I have not had enough time to take it all in and say that this all has solved all of the issues. I think the underlying big issue is presuming in any instance that there's reasonable grounds is constitutionally flawed, because the ability to search someone's person is a judicial decision. And you're conflating putting it in the law as an edict as opposed to a judicial decision that should be made. I'm not saying that there isn't any way around that. And I would like to have further conversations and will have further conversations with the chairman. I'm also not a DUI expert, but I know a lot of them. I'm not a constitutional law expert, but I know a few of them. And I think that those issues are where there's some tears in this. And I know this body well enough that you don't want to create a creature that goes across the street and gets struck down. I have had several lawyers look at this and say, yeah, pass it. We'll fight it and we'll win as drafted, the original one. And I know that comes across as kind of threatening, and I'm not trying to be threatening, but we do want to share with you our concerns. And then, that we're all, many of the folks in this room are lawyers, and we can all look at things differently. But those were some of the comments that I wanted to share with the committee. And again, I can't imagine the pain that Mr. Lamb has gone through, and I know that all of you feel the same way.
Any questions for Ms. Jill from members of the committee? Doesn't look like you have any, Ms. Jill.
Thanks, y'all.
Thank you. Is there anyone else who has signed up to speak to this prosecuting pack? Would you like to come up and speak? Mr. Smith, good to see you again.
Thank you, Chairman Smith, and congratulations as well. Here's the situation we're in. The current version of this bill correctly states the law when it comes to the issue that's being presented about getting a blood draw, or when an officer has exigent circumstances to be able to make the request. What the issue that my friend Ms. Travis was dancing around is the interpretation that the following phrase has been given by our Supreme Court. No person shall be compelled to give testimony tending in any matter to be self-incriminating. And that has been interpreted to mean that even though Georgia law says driving is a privilege, and by using that privilege and driving on the roads, we have given an implied consent that when an officer has reason to believe or probable cause to believe that a motorist is impaired, they can make a request and ask for a sample of blood, breath, or urine or other bodily substance. Several years ago, in a case called Olivec, the Supreme Court read the word self-incriminating to basically mean, in testimony, to mean that request. That when law enforcement asks a motorist, even though we've said I'm going to exercise my privilege to drive, and in response, I'm going to give you, I'm implicitly agreeing that you can test me if you believe that I'm an impaired motorist based on some acts or some other evidence you have. The Supreme Court has held that you can't be compelled to do that when it comes to breath. And then last week, in a case, that case is called Olivec. And then last week, in a case called AWAD, AWAD, they said you can't be compelled to give urine. That basically anytime a law enforcement officer compels or asks a motorist to do something, then that's a violation of paragraph 16. So 566 is this bill when we don't talk about the constitutional issue. This is a correct statement of the law based on a case called Cooper and the cases that came after it. This is good bill. Prosecutors would support it, but the problem is that it doesn't get us around the other issue. As Ms. Travis said, pass this bill, and then the defense attorneys are going to be able to come in and argue it's unconstitutional. They've already got the cases laying out, say this is unconstitutional, and it'll get struck down. There's a second step, and we're hoping to be able to work with the chairman and others to be able to get you something that not only helps solve the problem in this case, but for the future victims as well.
Are there any questions from members of the committee for Mr. Smith?
Oh, it's paragraph 16. If you, that's what I was reading earlier about the testimony. It's paragraph 16. That's the issue.
Okay.
The Georgia Constitution.
Any questions from members of the committee for Mr. Smith? Looks like you don't have any.
Thank you.
Anyone else that has signed up and would like to speak to this bill? Okay, Mr. Chairman.
Thank you, Mr. Chairman. So this bill touches many different areas of the law, and I've already started the conversation with Representative Bodie and Ms. Kendrick. If we are to pass a constitutional amendment, we're going to need a significant bipartisan support to do this. And this touches implied consent, not just in this case, but in every other case. So I look forward to working with the committee and those in both parties to see if we can find something, a solution to this problem. And I appreciate your time.
Thank you, Mr. Chair. All right. I believe that concludes the business of the subcommittee. I appreciate everybody's patience. Oh, so we're not going to hear that one today, but we will entertain hearing that. I need to get with the bill author a little bit more on that. And yeah. And so anyhow, we'll make it up to you. So anyhow, that completes the business of the subcommittee. We are adjourned.